Welcome you when you're live. Microphone's not working.
All right.
Okay, here we go. All right. Welcome everyone to the meeting of the Police Policy Committee, the first meeting of the newish year, and our new commission. It is 5:39 p.m. on April 9th, 2020. There, I'm acting as chair pro tem, and I'll call this meeting to order. I'm going to give a quick overview of procedures. This is a meeting of the Cleveland Community Police Commission Policy Committee is a lawful meeting. Under section 605.04 of the codified ordinances, no person with purpose to prevent or disrupt a lawful meeting shall do any act which obstructs or interferes with the due conduct of such meeting. Members of the public are invited to speak in accordance with the public comment rules. Disruptions, including but not limited to speaking out of turn and or making loud utterances that interfere with the due conduct of this lawful meeting, may constitute a misdemeanor and a violation of section 605.04. If this meeting is disrupted, I will call for recess and the room will be cleared. Persons who violate the city ordinances and commit misdemeanors may be subject to prosecution. When this body is able to return from recess, then in compliance with the Ohio Open Meeting Act and 101.021 of the codified ordinances, the meeting will be open to public hearing. So that's that. Welcome. I'm calling this meeting to order. The first item of business is the election of committee chair. As past chair, I've been working as chair, but obviously this is a new policy committee, a new commission, and we need to have a chair.
I make a motion to nominate you to be chair of the policy committee.
Oh, right. Sorry. A lot of practice. All right, I'm going to call attendance. Commissioner Morera Bonito. Commissioner Sarah Coleman.
Present.
Commissioner Rodriguez.
Present.
And I am also here. Okay. Election of committee chair.
I move to elect Pete Bandler as the policy committee chair. Second.
Okay. I guess we'll do a vote on that. Commissioner Morera Bonito.
Aye.
Commissioner Coleman. Commissioner Rodriguez.
Yes.
And all right, so I am now the chair. Thank you very much. Agenda review. It sounds like the revised agenda that we revised a week or two ago did not go out, but we have the correct agenda here, which includes the presentation of use of force and dialogue with the Division of Police as our first item of agenda after public comment. So just be aware of that. I think there are copies around if anybody would like to read them. Are there any comments or discussion needed on the agenda? Okay, hearing none. All right, we'll just move forward to to public comment. Are there any comments from the public?
It's just one Cameron Damascus.
Okay, we'll call Cameron Damascus. Good.
Good evening, everyone. So I wanted to speak with you all today about the drone policy that you all have in front of you. This was originally passed back in November, I believe November 20th, introduced on November 11th. And within 4 days of this being passed, the police deployed a drone at a protest on November 24th. That was in the Edgewater neighborhood. There was a march going on. I was present at that. I was told we were going to be cited for being in the streets, for using megaphones, anything like that. And several people ended up being indicted for engaging in free speech practices. At this same time, there was the deployment of a drone at the protest. I believe it was the only time a drone has been used by the Cleveland Division of Police. And so what I take from this is that the intent with these drones, like the number one thing that the police are interested in, is having this as a tool to surveil protests. If that is not the case, I would be interested to know of examples where drones were used between the 20th and 24th. My opinion, just what I saw from the police presence at that protest, it seemed like the police were interested in a show of force, and the drone was a part of that show of force. So shortly after this came out that the drone was used, the division was pressured for an explanation as to why they used the drone there, because we were told that drones would not be used to target protesters. The answer that Dorothy Todd gave was that it was for training. So the fact that she gave the answer of training, where I've seen a lot of the footage that was used, they were zooming in on protesters. You can call it training, but if it was training to surveil protesters. So something I think that needs to be taken away from this is, like, now I think we know the intent the division has with using these drones. And with that in mind, I think you all should think critically about whether you want to approve this when it looks like it's primarily going to be used to target protesters. If you all are going to move forward with passing this, there are a couple things that I think I just want to bring your attention to, knowing that we have this example of Chief Todd providing a basically made-up reason to use this against protesters. I don't think we should really be giving them a whole lot of discretion when using this. So line B4 talks about how the chief can authorize the use to fly over large crowds if necessary for public safety purposes. Public safety purposes is very vague, and so if this has to be passed today, there's enough pressure to make sure that it passes. That's something that really should be scratched. That's going to be used just to target people. And the other thing I would really recommend is to change the part about conducting surveillance to just say conducting surveillance. Don't say for individuals or groups within large crowds. That is part, what is that? 4A. So, wait, sorry. 4C1. Conducting surveillance of individuals or groups within public demonstrations. So this is based off of the Oakland policy. And the Oakland policy just says they're forbidden to use it for conducting surveillance. So having this like specific carve out, again, I think the division has shown like bad faith in terms of using these drones. So just limiting the ability of them to target people using free speech practices. So yeah, the changing that to just be conducting surveillance, and also just don't give the chief the ability to authorize surveillance of large or flying over large crowds, because I feel like that's just going to be used. Yeah.
We're going to start with the presentation on use of force by division police. We had about an hour scheduled for this, so we're probably a couple minutes behind.
All right, I'm gonna try and keep it as concise as possible. All right, so
Before you start,
Yeah.
Pete, if you could just let them know, this presentation's on our website for today's calendar, so if someone wants to follow along, if they can't see the screen.
Okay, so yeah, apparently the slides are on our website if you're watching this online, and you can follow along more easily that
we
way.
go to the next slide.
Thank you.
All right, some of the objectives of what we're gonna try to do today, we're gonna talk about what the definitions of the levels of force are. What does the levels of force mean? How we determine the proper level of force. How the supervisors then review that use of force, as well as the supervisor's investigation. So this first slide has our definitions. One is de minimis force. It's not a reportable type of force, because it's not expected to cause, not reasonably likely to cause pain. Basically, it's officers using their hands to stop somebody. They can use a tool to keep people from coming forward, but it's, again, not going to cause pain or reasonably likely to cause pain. Level 1 force, and for these level 1, 2, and 3, I've kind of highlighted the really important portions of those definitions. Each of the definitions has some specific uses of force in them, but those are very broad and they don't cover all of the uses of forces that could fall under that level. So the primary determination of what a level of force may be basically is determined by the amount of pain, whether there's injury or whether there's serious injury. So for level 1 force, it's reasonably likely to cause only transient pain, like a pinch, it's going to hurt, but then it stops, or disorientation during its application, but is not reasonably expected to cause any kind of permanent injury, or not actual injury or result in a complaint of injury. Some of those for level 1 are pressure point compliance. Certain nerves in the body you compress to get compliance, as well as joint manipulation. It does not include escorting, touching, or handcuffing with no or minimal resistance. That would fall under de minimis force. Yeah.
Can you explain what would cause the disorientation piece? Is that the pressure point?
Pressure point joint manipulation. A nice, have somebody bend your wrist back and it may disorient you a little bit. It's a tool we can use to aid in handcuffing. It's not likely to cause any injury whatsoever. So an example is officers are escorting an unhandcuffed person. There's no handcuffs on them. As they're walking, that person decides to break away and try and run. A result, all 3 of them fall down into the grass in the front lawn. Nobody's injured. So at that point, the officers have not consciously used force. There's no injury or a complaint of injury. Depending on what the officers were doing when the person tried to break away will determine whether it's de minimis force or a level 1. If they're just guiding the person, not exerting any kind of pressure or anything, then it's just going to be de minimis force. However, if they were using a joint manipulation to move them along and they all fall to the ground, that would then be a level 1. So next up we have,
If we talk about the pointing of the pistol real quick, because I know that's come up on this board before.
Okay.
Can you explain what exactly that means and maybe like show a visual difference between the low ready and the high ready position?
I can do that. So I'm going to use my hands for that, obviously. We are required, if we draw our firearm but do not point it, we keep track of that for data. However, if you draw your firearm and point it at a person, that is considered a level 1 use of force and requires a review by a supervisor. So really quickly, this is pointing. An officer may have a gun in the stool position in which the barrel is going to be pointing between their feet, or they could have it at low ready, which again, the barrel is pointing at the ground. It's not pointing at a person. That's just a real quick, easy explanation of that. So level 2 and 3, those are kind of the meat and potatoes. Level 2, it's force that causes an injury, could reasonably be expected to cause an injury, or results in a complaint of injury, but doesn't rise to a level 3. Specifically in this definition, use of a CEW, commonly known as a taser, any of our impact weapons, AS batons, beanbag shotgun, a takedown, specifically closed fist strikes are included in this section. The last phrase in this particular definition, so use of an impact weapon or a beanbag shotgun except for a strike to the head, neck, or face with an impact weapon or beanbag shotgun. So as long as you're using it, you hit them in the body, someplace other than the head, neck, or face, it's going to be considered level 2. If you use an impact weapon and hit them in the head, neck, or face, that's going to raise the level. So level 3 force includes uses of deadly force, force resulting in death or serious physical harm, which is actually defined in the ORC. Uses of force resulting in a hospital confinement because of the force injury, and uses of force resulting in loss of consciousness. It also includes neck holds, extended CEW taser applications, and it also includes any level 2. So if you have a level 2 use of force that's on a person that is handcuffed, that's going to raise it to a level 3.
Could you, hold on one sec.
Yeah.
In terms of the level 2, the closed fist strike to the head, could you talk about why that's not level 3, given that, you know?
We're actually going to talk about that a lot. No, just a minute. So in the example I used in the first slide, for the level 1 force, they're escorting the male, they're walking with the male. Had they used a leg sweep to trip that person to fall to the ground, that would then be considered a level 2 use of force, a takedown. We have previously discussed a fist strike to the head. But again, as you note in the last phrase of level 2, the only time a strike to the head rises to a level 3 is if it's an impact weapon or a beanbag shotgun.
Or if you're handcuffed.
Or if they're handcuffed, yes. So as far as a strike to the head, what's going to determine the level of force, as long as none of those other things apply, would be the injury or pain caused. Did you have a question?
Yeah. So I have seen in some other division, in other police departments, where a closed fist strike to the head is a higher level.
Mhm.
Can you speak to why you chose, the
Well-
division chose to leave it at level 2?
Ultimately, most of our definitions were extracted with very few minor changes from the consent decree. So the language you see here is largely from the consent decree. So like I said, so just again, a level 2, if it were to cause serious injury, unconsciousness, or hospital confinement, that would also raise it to a level 3, based on the level 3 definition. So we have a use of force. The officers report it to their supervisors. How does the supervisor go about determining the proper level of force? First thing they should do when they come on scene is talk to the subject of the use of force, because they're going to check and make sure he's getting medical attention if any is required. They will also talk to witnesses, the officers themselves. For level 2s, those interviews are required to be done separately. No group interviews with our officers. They will refer to the definitions in policy. They may call their lieutenant, their captain. They may even call the IA superintendent if they have a question as to what the level of force is, to get some clarification. Now you see I have may in red here. They may view the officer's WCS on scene. However, the technology we have right now does not allow for an easy or efficient viewing of the WCS. So for level 2s and 3s, they have the opportunity to review that level of force or review that WCS for the level of force as they're doing their investigation. The division is looking at the possibility of changing how we're handling level 1 use of force. So we may be looking at that a little more closely.
What are they looking at?
Right now, and we'll go to the next slide. Right now, for a level 1 use of force, it does not require the supervisor to look at the WCS at all. Because of the timeline to complete their investigation for that level 1 use of force, they got to do it before they go home. So the officers aren't downloading their WCSs until the end of their tour. They can't watch the video. So we are looking at either potentially extending that deadline so that supervisors have an opportunity to look at the WCS, or having someone else in the division in maybe an audit type capacity to look at those level 1 uses of force. The data that we collect, we've collected a lot of use of force data over the years. We're using that data. We're using feedback from our force review board. And that's kind of where this has gotten us, that we're looking at making some changes because we feel they're necessary. So on a level 2, the investigating supervisor, I said, will look at it during their investigation. And on any level 3, those are investigated by FIT. So obviously the IA sergeant that's assigned that case is going to watch that video. I know it has come up regarding officers being able to look at their WCS while they're completing their reports. When we drafted this, we did a lot of research of all the other agencies across the country. And as far as officers watching their WCS on a level 1 or a level 2 to complete their reports, a lot of departments allow them to do that. And we didn't see a reason not to. However, when it comes to a level 3, you are not permitted to watch your WCS until you get permission from a FIT supervisor, which is going to be somebody from Internal Affairs, the OIC, or the superintendent, or supervisor from our homicide unit. Yeah.
Do officers, when writing reports generally, let's say it was a really chaotic scene, there was no use of force, but while they're writing their reports, generally, would they review the WCS? Is that something officers do?
I know officers do. I know they do, especially in those chaotic scenes where something may have happened when the two partners are separated. Only one person's writing that report, so they may go back and look at the video. In fact, we've actually had a case recently where officers, there was some confusion as to the level of force. It ended up being a level 3 force, and they did get some disciplinary specs for watching their video without permission from a FIT OIC.
I have a question.
Yeah.
Sorry. Yeah, you talk about looking at policies around the country. It's interesting because the Police Executive Research Forum does make a recommendation for doing a perceptual interview first before they view the footage, right? So what's your, I mean, that seems like a pretty solid approach, and based on the source, that I'm just wondering if you're aware of that, or
I am aware of PELC. We look at PELC as well. How we investigate our level 2 uses of force.
sorry, what's PELC?
It's not PELC. I'm sorry.
PERF?
PERF. Yes.
Okay.
Sorry. PELC is the Police Executive Leadership Committee. Leadership training. Sorry. For our level 2 force, the supervisor is going to interview the officer prior to them completing the report. The supervisor is required to report to the scene. They will do interviews separately with the officers. If
For
you have
level
2
two?
officers involved, 3
So level
officers
2?
involved.
That's
What's
level
that?
2?
That's for level 2. For level 3, it's entirely different because IA supervisors come out. They're going to do an initial 17-question Garrity statement to get the basics of what happened because we have to worry about the criminal investigation before we do a full Garrity interview. Although we do those full Garrity interviews within 72 hours with officers who use level 3 force. As part of our investigations, whether it be a level 2 or a 3, the supervisor has the ability after they review the WCS to either raise that level or lower it, depending on what they see. They may look at a video that an officer thinks was de minimis and they're going, nope, that's a level 1. We need to do the report. It may be a level 2 that they're like, nope, that's a level 1. So,
So how fast are the reports completed by the officers? Because so you were saying that the use of force level is determined before the end of the shift.
yes.
And then are officers completing these reports after the shift?
They are required to complete their blue team entries, their use of force entries, prior to leaving at the end of their shift.
So I guess how do they know whether it's a level like? So I mean, do they have to wait until they get the determination from the supervisor of what level of force? it is before
Typically,
they
you
do
have the
it?
supervisor comes on scene. He's going to look at all that stuff I mentioned, talk to witnesses, and he'll make a determination as to what level of force it is.
And then at that point,
So that-
after then,
That officer's aware of what the force is when they do their entry for the use of force. All right. Next, we're going to look at an actual case that we had. I was going to show some video, but I don't think we'll be able to do that. It wasn't very good video anyway. As you can imagine, when officers get in close together, all you're seeing is darkness because their cameras are, putting up against one another. So in November of 2023, at approximately 17:30 hours, that's about 5:30 p.m., officers responded for a domestic dispute. While they're on their way there, they discovered that this male potentially has warrants. So they get on scene, they talk to the parties, they learn that there was no physical altercation at all. It's not a domestic violence. And as they're discussing what they're going to do next, they mention detaining the male subject to check on his warrants. He overhears them use the word detainment, and he starts running. Officers chase him across the street, catch up with him. As the first officer catches up with him, they immediately, subject starts throwing punches, officer starts throwing punches, and one of those punches actually connects with the subject male's face. As soon as his partner gets to him, they're able to get him under control, they get him handcuffed, they call supervisor, and they call EMS. Both come out. The male is eventually taken to the hospital, will be checked, and he's TNR, treated and released, with no injuries reported whatsoever before he gets booked into jail. You go to the next one. So for this, I put up the definitions for level 2 and level 3 again. If you're looking at this by the definitions and the objective facts that we have, this subject male was aggressively physically resistant. Based on our use of force policy, he was fleeing from officers to evade capture. He's throwing punches. The officers applied force that could be reasonably expected to cause injury, a close fixed strike to the body, which is going to automatically make it a level 2. One of those punches did contact the male's head. If they had used a beanbag shotgun or an impact weapon, of course, it would escalate. If the male had been handcuffed, it would escalate. This particular force did not result in any injury, didn't result in any hospital confinement or loss of consciousness, and the subject male wasn't handcuffed at the time the force was used. Therefore, because he was still physically resistant, that would make this a level 2. There's no injuries. It wouldn't escalate to a level 3. You go to the next one. So here are a few other cases, 3 that we found. In talking to Lieutenant Syka, we have had a total of only 6 head strikes since 2017 that were reported. In this first one, they went there to arrest him on a felony warrant. He became aggressive. They had to take him to the ground. So we have a level 2 use of force already because they took him to the ground. He continues to struggle with officers as they're trying to handcuff him, even though he's laying on the ground. At one point, an officer's leg gets close enough to him, he bites him on the inner thigh. Hard enough that that officer had to be treated at the hospital through his jeans. He bit him that hard. The officer strikes him in the head several times to get him to release that bite. The male gets treated at the hospital for an abrasion. Again, not serious physical injury. The officer was treated for the bite wound. This one is in 2020, so out of an abundance of caution, they did make it a level 3 use of force. However, by definition, there's no serious physical harm, there's no loss of consciousness, hospital confinement. This really should have remained a level 2. In 2020, our use of force policies were still pretty brand new. We just revamped them in connection with the consent decree. So they were still pretty new, and this is the first time that they were applying these uses of force to a head strike. So I think it was an abundance of caution that they did make this a level 3. Next case, the officers arrive for domestic violence. They approach the door. They speak with a child that's at the bottom of the steps. He says they're upstairs. At that point, he hears a woman screaming. So the officers run up the stairs to the second floor apartment. As they enter the apartment, they can see the male is strangling the female. They can listen. This video I have seen strangling the female. As the officers approach him, giving commands to let her go. Only as the officer gets right up to the male does he let go, and immediately spins and throws a punch right at the officer's head. The officer is able to duck, delivers one closed fist strike, which happens to connect in the head. His partner gets there. A little bit more of a struggle. They get him handcuffed. Again, EMS and the supervisor are called. He gets treated for a small cut on his face. The last one, which is still an open case, but a few facts I can give you. Officers responded to a place entered. It evolves into a foot pursuit, at which time they discover the male is armed. He had a gun. During the struggle to handcuff him, again, he bites an officer. This officer delivers one closed fist strike to the subject's face. However, this time they broke his nose. That qualifies as a serious physical injury. Therefore, this one is being investigated as a level 3.
So, question. So it's interesting because like the force policy says confinement to the hospital, and clearly in the first 2 cases on that page, 2020, 2024 case, there was no confinement to the hospital.
There's actually no confinement in any of these cases.
Yeah, right.
They were all treated in release.
Yeah, I know. That's what I'm saying is like, so then I guess how do you discern, like a broken nose sounds like a pretty serious injury, but he wasn't confined to the hospital. But are there lists of like, here are serious injuries, or how is that determined?
Hospital confinement means that you're leaving the AR and you're being assigned a hospital.
Right. That's what I'm saying. So obviously
That's hospital confinement.
The broken nose isn't that because he's not
Broken nose is not that,
but
but
yes, it's level 3 because
it's a serious physical injury.
So
Yes.
like, what's your list of serious injuries? Like, or is it subjective? Or
Serious physical injury is defined in the ORC.
Okay.
So that's the definition we use.
Yeah. All right.
So as I mentioned, the 2020 case was investigated as a level 3, but really should have been investigated as a level 2. The first 2024 case was very similar in that it was investigated as a level 2 because there was no non-serious physical harm. The last one obviously was different because there was serious physical harm, therefore it was a level 3. And with that, are there any other questions?
So, when you talk about that it's investigated as a specific level,
Yes.
is the difference who investigates it? Because I remember the level 3, they're investigated different, like,
The only difference is between level 2s and level 3s.
Right.
Level 1s, it's a supervisor review because those are very low level uses of force. Level 2s, it's a complete investigation by the supervisor. And then level 3s are investigated by internal affairs.
Okay, cool. So when you say it was investigated at a level 3, that means internal affairs.
Yes.
Are there any other differences in how they're investigated other than who's doing the investigation?
As I said, level 1 is it's a review. It's not a heavy use of force. Level 2 requires a full investigation. And then level 3 is going to be a full investigation.
Or just who is doing it?
Yes. Pretty much, yes.
Can you explain to them a couple of terms that they'll hear? Blue team, what that means?
Blue Team. Blue Team is our tracking software. We use it for many, many things. We track a lot of our data through Blue Team. That's where the officers make their entries, and that's how we got rid of a whole lot of paper. It also gives us the ability to pull that data. So, as I mentioned, in a lot of what we're doing, that data is feeding our revisions to policy. It's feeding our training curriculums. Same with the Force Review Board. So that's a good system.
And that all uses of force are entered as a blue team, right?
Yes.
Okay, so that also system-wise, can you explain the difference between the FIT team and the Force Review Board and how they interact?
Okay, the FIT team is what will get called out to investigate level 3 force. Depending on how serious the level of force is, the IA superintendent has the ability, working with the FIT OIC from homicide, to determine who needs to be sent, whether we need to send just a couple of guys from internal affairs, or whether we're talking sending everybody from the homicide unit from internal affairs. That's the FIT team. They're going to investigate all level 3 uses of force. The Force Review Board comes into play later as a representative from the chief's office, typically a deputy chief, somebody from the Bureau of Compliance, somebody from internal affairs, somebody from the training section, and somebody from the district where the force was used. We review the case after it's been through the entire process, it's been investigated, any discipline that has come out of it has been completed, and we look at it from a quality assurance point of view, where we're looking for, can we make our policies better? Can we make our tactics better? Can we get better equipment to help the officers? Those are the things Force Review Board does, and it does give us a lot of information that we can plug into our training and our policy. Yes.
Once
Here's the mic.
the responding officer does their incident report, that is done in blue teams, correct? Or
The
it's not?
actual incident report for the crime that was committed to me, that is done in an alarm system,
Okay,
different system.
so there's an incident report and then there's a review of the incident report.
Well, the incident report will be completed. That will be reviewed by a supervisor. The use of force is a separate entry in a different system that then gets investigated by the supervisor.
And when the supervisor does that review, does that generate a separate report?
It will be the supervisor's investigation. The incident report will be included in the officer's blue team and in the supervisor's investigation.
Okay, so when you see in a report review, usually kind of they list at the bottom or somewhere what all they looked at.
Mhm.
If you see a reference to blue teams, can that be interpreted synonymous with a
use of force entry.
Yeah, okay,
Yes, the use of force entry.
thanks.
That was a really helpful line of questioning. So I guess when the investigation is completed, what is that called and where does that live? The use of force investigation that's either handled by the supervisor or the IA.
50, yeah. Level 1s and level 2s, they're completed in blue team. Blue team is a part of IA Pro, a larger system. So once the officer completes his, it goes to the supervisor. He will do his review or investigation, and then it will go up to the chain of command to their commander, who ultimately decides whether the force was appropriate or not. If there's discipline involved, it will go to case prep. If not, it will go to the deputy chiefs for information so they know what's going on under their commands. Ultimately, it will get routed, once everything is done, it will get routed to our IA administrator, IA Pro administrator, who will move that from Blue Team into IA Pro for storage. And that's where it will live for the rest of its life. For a fit team, however, Internal Affairs will do their entire investigation in IA Pro. They don't use Blue Team at all.
So is there a name for the report that gets done?
It's a use of force
So
report.
the officer completes the use of force report,
Mhm.
and then
Yeah.
it just also called a use of force report.
Yeah, we have in Blue Team, there are several incident types you can use. We use it for a lot of different stuff. So you may have, somebody wants to go to training, that goes into Blue Team. Somebody gets injured, that goes into Blue Team. So you have a whole list of things. Use of force is one of those, and that brings up the use of force screens.
So one thing is, I'm thinking about this from an accountability standpoint of, when we're reviewing discipline files, generally when we're sent materials, is that is the officer's use of force report and the supervisor's use of force report generally is included? I guess that's a question for Jason.
Yeah, so if it's a closed file, you're gonna get everything that was considered in that case. So if it goes all the way through discipline, every piece of evidence that was presented in that will come as an attachment to that file. So all the video, all the written reports. So yes. Pete, did you have?
No, just some, the mic.
So one last thing, the reason that spawned this, to my recollection, was there was a memo, a DN, for those who
Yes.
are new. Divisional notices are memorandums from the command staff to the entire division that explain something new occurring typically, or an opportunity available. So a divisional notice came to us and it had to do with closed fist strikes,
Mhm.
right? And the question we originally had was, it looked like it was a policy amendment done through the DN, and our question was, if closed fist strikes need to be changed in the grouping or the way they're investigated, why aren't we just changing the policy, right? So I think that the understanding of that is what spawned part of this discussion,
Right.
and the wearable camera issue with the different levels. So it was two-pronged, but that DN is still pending on if closed fist strikes need to be reclassified. Is that your recommendation to this board, that we look at closed fist strikes and they need to maybe be changed in the policy to only be a 2 or a 1 with the exception of the 3 thing?
So a DN is, if you look at our definition of a divisional notice, it is a temporary order. It's something we do as a stopgap until we can get the policy revised. That policy revision never happened. The definitions you see are the definitions we've had for years. All we are asking is to be able to follow the definitions that are in our policy by removing that DN or approving the DN that we forwarded so that we can, which I think was essentially to rescind that DN. I should mention the 2020 case that I mentioned that was made a level 3 in an abundance of caution. That's what generated all those conversations. So again, really new policies. First time we're applying them to a situation may have had something to do with that decision being made.
And with that DM,
That was
2020, the one that you guys just did.
The one with the close fist strikes line in it that was a 2023 DN, I believe.
What was the original one though? The original one would have been shortly after, like 21, 20.
and then the DM that you're saying that changed, that said, so you're asking that DM to go away, so that's, we're just applying the policy as is already written. When was that DM sent out?
That DN hasn't been sent out. That's the one that you guys have here.
Okay, So you're saying that the one that you are asking that
To
the-
get rid of was written
in
back in
2020?
yeah.
In response to the
2020 or
2020
2021, I'm
case.
not sure.
Okay. And that basically classified closed
Closed
fist
fist
strike
strikes to
as
that as a-
11.3.
As a level 3, yes. Which is actually in opposition to our policy as they're written.
Yeah, so you had said that in terms of closed fist strikes, I think you said have only been six since 2017.
Yes.
Is that marked a shift? You feel like it's fewer?
I just think
or-
it shows that they're very uncommon. We don't train officers to aim anything in these regions. Your head, your groin, those are off limits areas for any level of force, really. But things do happen sometimes. So I think having 6 only since 2017 shows how rare those are.
Yeah, I'm looking at, thank you for sending that. I was actually looking for, Ohio Revised Code just to get more information on what that says in terms of
section.
injury. It's section 2901.01. Mr. Norton sent that to us. So it's a lot to look at offhand. So can you talk more about, like, from your perspective, how often what the Ohio Revised Code means in terms of how things are investigated and what.
I will tell you that most officers aren't going to go back and look at the Ohio Revised Code to see what the definition of serious physical harm is. They're aware. I mean, we're talking about broken bones, injuries that would require stitches. You pop somebody's tooth out, that's going to be serious physical harm.
Yeah, there's things on this list are serious physical harm means mental illness or condition of such gravity that would require hospitalization with prolonged psychiatric treatment, substantial risk of death, physical harm that involves permanent incapacity, partial or total, or temporary substantial incapacity, permanent disfigurement, or serious disfigurement if it's temporary, acute pain of such duration as a result of substantial suffering that involves any degree of prolonged or intractable pain. And then it goes into property. So those are the main, that's the definitions.
Yeah, that's yeah.
Am I missing something?
That's kind of what I remember from my academy school days.
Okay.
And one last question that comes up with the community. So, when an IA investigation is completed and it's found that the force wasn't within policy, does IA always recommend to the prosecutor that the officer be charged?
Every case that IA does is taken to the prosecutor for a prosecutor review. It's up to the prosecutor whether they charge or don't charge. Anything that is found out of policy will definitely result in administrative divisional charges.
But not always.
It may not always end up in criminal charges. No, that's up to the prosecutor.
So a closed fist strike that is out of policy may not result in an assault charge.
Correct. That's really up to the prosecutor. We don't have a whole lot of input into their decisions. All right. Well, as an exit, I would like to say welcome back to the prior commissioners and welcome to our new commissioners.
Thank you. Thank you, Captain Simon.
Certainly. Okay. All right. So now we're going to move on to old business, which is the unmanned aerial systems DPO. So this, as you may or may not know, as Mr. Mask, our speaker earlier, our public commenter mentioned, this was passed by the full commission on November 20th. And we sent to the Department of Justice and monitoring team for review, and we got that back. And in the meantime, so we've incorporated those comments into this draft. And we had a lot of conversation. Been talking to people about this policy to make it better since it was coming back to us. So we've done some changes to it, and actually most recently, somebody who took their time getting back to me and just sent something this morning. So you all got that memo from him, and then Mr. Nordine incorporated that into the draft we have before us. At least some of the changes that we suggested. So that's where we're at now, and we have this. I want to thank Alex Nordine for his work on this over the past couple of weeks. He really, I think, tightened things up and made it, organize it in a better way than it had been. So we really appreciate that, as well as the input from people in the community, including some of our surveillance tech work group members. So with that, I know that this version went out, substantially the same version went out on Monday. A lot of you are familiar with it from before that. I know it's not a ton of time, but we have a little bit of time. We can talk through this as we need to make sure this is something that we're comfortable with. And if we're not, we also got some comments from the public, from Mr. Damaska, and we can consider those if we need to. But overall, I feel like we have a pretty solid document here that's in better shape than it was. Of course, after this, I'll still have to go back to the DOJ.
So I'm sorry, I had a very busy day at work. I was not able to look at the what Mr. Martin said. Can you?
That's fine. They're tracked in here. Miss Alex already put those.
Yeah, could you maybe go through some?
So yeah, maybe that would be best to do it.
Okay. What I will say is most, if not all, of the changes that he suggested are
One second. Whose changes are we going through?
The track change,
John Martin.
track changes are from John Martin.
Okay,
who
can we
was with the
start with
public
who John Martin is?
He was
Great
with the,
question.
he was with the Public Defender's Office up until recently, and has been an active member of the surveillance tech work group for at least a year. And that work group hasn't reconvened, but I've been in contact with them about this particular GPO while the commission was sort of really functional.
So the changes that he proposed and that he and I discussed and ultimately implemented in the document are essentially non-substantive in nature. So they didn't change anything of substance. Really, there were just certain things that were meant for clarification purposes and to just be a little bit more understandable, I believe. The changes are track change, so you should have those in front of you. I'd say of particular importance, he suggested a few things that we discussed and determined weren't necessary. For example, he suggested page 6, part 6, that we insert property interest for reasonable expectation. After discussion, we determined that that was sort of superfluous based on the language that was already provided in there. We did eliminate, as he suggested in that second sentence, for the purposes of obtaining information. We thought that was a good suggestion. Otherwise, most of the changes just are as he suggested. We did add a subsection under part 14B3 to involve a collision for data retention purposes. And those are really just minimal changes.
Oh, okay. Thank you. So I think I got just overall questions because I know this came November 20th and there was kind of concern about receiving it late and who was working on the policy just in general. So especially since you said we weren't in session
So it's this, and I'm new to the work group. So can you explain overall how this took place, as well as just an overview, right?
You mean since November 20th? So what, it was sent before that.
So even what we received on November 20th, it was received a few days before. And we know that there was a few audience members that came. So overall, the process in just developing policies, particularly even this one, in prior, my understanding is that a variety of stakeholders will work on the policy. So that has occurred as well. I know it went to the DOJ. So for me, I need better understanding.
So before November, we had the surveillance tech work group that looked at it. Particularly Brian Ray at Cleveland State, who's part of the surveillance tech work group. He, the law student worked on it. They looked at the Oakland policy, so a lot of it came from there. We had discussion with the division's policy unit and made adjustments there, and then we came in on November 20th, and we even made some adjustments at that meeting, right? If you remember that, based on some last minute input from not only from the community but from Brian Ray. I think he was the main one. So we made that adjustment. That was around the crowd at the protest. After that, it went to the DOJ. They gave some comments on the monitoring team as well, and we looked at those comments, or I looked at those comments and incorporated them. And then in the meantime, because we had this window of time to work on it, I talked to people like Brian Ray, John, who's with CSU, Gary Daniels at the ACLU, and John Martin most recently, and they all had some input, and some that resulted in what you have right now. And Alex Nordy. Am I saying your last name right, Nordy? Yeah. Alex helped us. We've met. Yeah, that's right. Yeah, sorry, I forgot about that. It's been a lot of time has passed, but a lot has happened.
Okay, so especially if you two met, so just to keep in reference, we don't want to violate OMA and ensuring everything is public.
There was no commission at the time, and Commissioner Bino was not a commissioner.
Okay, so I wanted to state my concern, especially since we're having conversations about work and it's not in an open setting. So I just wanted to put that in my record.
Are you satisfied with the response, or do you have any questions?
No.
Okay. No, you're not. You are satisfied. Okay. Okay, so I'm not sure what would be the best, because some of us have been living with it for a while, and others, are newer to it. So I want to respect that, and we have time to sort of ask questions. We can run through, I don't know about line by line, but look at each section and sort of see what jumps out of this.
I have something, but also, do you guys have a preference of going line by line, or just going through and through things? Since this is my new deal.
Under the chair, I would suggest maybe talking about overarching issues or concerns generally within the policy, and then go line by line after we've discussed. That way we have the background of what we're looking out for as we go line by line.
Sure. So, we have the purpose. And one of the issues that came up earlier that I mentioned was surveillance and crowd control kind of issues. So that's been something we've dealt with, and trying to find the nuance between allowing use when public safety or there's probable cause for a crime, and free speech. So we kind of tee those up in the beginning, talking about respecting the rules, laws, regulations of the Constitution, so Ohio and the U.S. Constitution, FAA, and all other applicable laws and policies, right? So freedom of speech, we wanted to highlight that, freedom of movement and all those rights that we sometimes take for granted. There is a GPO that we've referred, that's a relatively new addition of crowd management. And you look at the policy and what the efforts to not invade a reasonable expectation of privacy, for the right to be secure against unreasonable circumstances. So those are the overarching aspects of it. The definitions, I hope, are pretty clear, looking at what each piece of it is, and where we, this was also developed a little bit more with Alan. There's been some back and forth around, talking about the UAS, the unmanned aircraft system versus the UAV, which is the actual vehicle. So those definitions are to help, make it all make sense. Procedures, we have the general pre-deployment and deployment requirements. So looking at everything from inspection, when you're putting it out there, the need to consider, shall consider, at the top of page 3, you shall consider alternatives deployment, and complying with the rules, and all that is about how do you get ready to use it and how do you deploy it, right? Note section 2 is pre-authorized, and this again, thanks to Alex, we really kind of narrowed down on okay, these are the cases where it's clear that you can use it without any problems, right? You've got mass casualty incidents, these kinds of things, scene documentation for evidentiary investigatory value, you're training somebody, or if there's an imminent risk to officers of public safety, and you have some examples there at the bottom of page 3 and top of page 4. Then we get into the section 3 on page 4 about what requires additional command approval. So you've got these situations where yes, you can use it without really getting that approval, and the rest is all about when you need that extra approval. So it's the chief or the designee or the chief designee at the rank of commander above, right? There's also the officer in charge of the incident commander shall seek approval. So there you have the situations where you really need to have more than just assumption that it's okay. And then there's the prohibited use, where you're not allowed to use it. And then the rest of it is more boilerplate. Some of it's not. I mean, it's the standards of equipment, how things are reported, protecting rights and privacy. What happens when you're in an airspace with other planes or helicopters or what have you, particularly helicopters in this case. And then what the pilots are responsible for in section 8, toward the top of page 7, the visual observer, the pilot, the program coordinator, and I believe there's a supervisor. Down at the bottom of page 9, the supervisor. So that the main part of that is what the coordinator is responsible to do, right? And then you look at section 10, emergencies and collisions. What happens when that happens? And training, what to do with the captured media and the data, how it's obtained. The data sharing. So it goes by section, and then the accountability, how the log is kept, when that happens, how that's reviewed, and how it's transported, last but not least, transported and inspection. Went pretty quickly, but I hope that we can go back and revisit sections or anything that jumps out, and we can even take a minute to read it to me.
I'm not sure that going line by line at this point is necessary because it's already gone to the DOJ and been approved once, but I think there are people concerned with specific sections. I think one thing to Mr. Damascus's point, I think for under section 3, so B 1 through 5, one thing is we added the thing about that about it being the use of drones needing to be part of the incident action plan or safety plan for outdoor public events. I believe that's different in this draft. And so what I'm wondering is, does that address some of what maybe number 4 was covering prior? And I think I agree that the idea of public safety purposes, then if you just say, well, it's for the purpose of public safety, does that just kind of create a too large a catch-all.
Yeah, that part about the public safety plan still isn't enough. So we'll have to.
No, it's right there. It's number 1.
All right, there it is.
Yeah.
Um,
But I believe it's something we added. And so what I'm wondering is number 4 redundant? Like, is that addressing most of what number 4 would? Because if then in an incident action plan, they're saying may need use of drones, that is, like, if they're not including that, yeah, because I think it's a point well taken that the public safety purposes, as determined by who and what type of public safety purpose. So yeah, please, you may.
I think the intent of number 4 was for those scenarios where the outdoor events or outdoor protests or what have you weren't pre-planned. So in the event a large crowd gets together and public safety issues arise, there might be a scenario in which the division might want discretion to utilize drones without sort of specifying and limiting that scenario. Now, if public safety purpose should be elaborated upon, we could certainly do that. That's up to this committee.
How would you suggest elaborating on
So there's always sort of an objective component with the Fourth Amendment, and it's what's reasonable and what's a reasonable expectation. The force usually needs some articulable reason for utilizing various surveillances and technologies. So if we want to embed that in there, it can narrow it a little bit while potentially still giving the division a certain level of discretion in the event that two crowds unplanned converge and start going at each other, and the division wants sort of an aerial take on what's going on.
which was John Martin's point. Yeah.
So, yeah, I mean, that's helpful. I also think looking at that section B there on page 4, there's also item 3, which we added some language, and it's, other circumstances where there's probable cause that a crime is being or has been committed or where public safety is being endangered. That would meet. So that's really about a warrantless search under the Fourth Amendment. So I'm wondering, yeah, it just feels like trying to figure out how necessary 4 is,
Yeah.
given that we have 1 and 3 there.
Agreed.
Yeah, I don't know. It just seems like it does give a little more discretion than we may want to. I mean, I get it. I mean, there's that thinking about. So let's think about that for a minute. Let's keep that. I also want to. Attorney Graham is here and Captain Simon, so we might call him up in a minute.
Yeah,
Because we asked him to be here.
I have a question, and then I think if we want to get our policy back. On section 3, what I'm confused about is B 1 through 5. Even in those situations, does a 2A circumstance have to be present? So, like, these are the authorized uses. Okay, pre-authorized uses. And I guess we're saying, so for B 1 through 4, you're saying that is completely discretionary regardless of any pre-authorized use is at play?
I wouldn't say it's completely discretionary. It requires the approval of the chief or the subject director commander above.
And
So
then
that
that
doesn't
person's
mean-
going to use their discretion as to whether or not it could be deployed, regardless if one of the pre-authorized items are in play. I understand the policy's not expressly saying you have discretion, but
So what you're asking is if the police are using B4 to have a command approved use, does that also want, when they're reviewing it, to review whether they're going to give approval, do they also have to meet the criteria under A?
And it sounds like no, but they would be limited by the prohibited uses under 4, correct? So when you're looking at, okay, somebody's going to use their discretion to say, okay, am I going to okay this deployment? Their guardrails are essentially going to be what's in 4.
In section 4, prohibited use. You're talking about section 4 prohibited use?
Mhm.
Yeah. Yeah, I mean, those are guardrails for sure.
That's my understanding.
I guess just to me, it's kind of confusing because, I mean, it says for public safety purposes. And it seems like there's no parameters around what that is or could be.
Right.
And it kind of conflicts with the 4C1. You're prohibited from conducting surveillance of individuals or groups within public demonstrations. But then we give them the discretion to do exactly that
Right.
if it's necessary for public safety purposes.
I remember
So you're
saying
right.
something.
Your main concern is with B4.
Well, maybe I'm speaking out loud because I don't know if the way to address it is through B4 or 3, but to me, without parameters around what a public safety purpose, to me, those two provisions directly conflict.
I remember, okay, part of what, a discussion that was had around this, one was traffic, like a traffic situation where there's a crash over on, there's a intense traffic situation and officers are on the ground, directing traffic, but they don't know, they might not be able to know that over here is what's happening with cars over here. I remember that was like one of the things that was an example that was given. I know Ryan will.
I just wanted to just add, I share Tara's concerns. When I read B4, I just think about we only have one incident where these drones have been deployed. And I think that, I'm making an assumption, but I think that the police would have thought, the chief would have thought that that was a public safety purpose that she was using that drone for. And I don't think there's agreement about that being used for public safety purposes. So I share the desire to sort of flush this out a little bit because I think that we want to make sure that we're protecting people's constitutional rights. We also want to make sure that we're not handicapping the police in situations where they may need to use the drones. But I think that we have to figure out how to make this less subjective and kind of tighten sort of how that can be interpreted.
So welcome to the table. Did you have a comment for the record?
Yeah, real quick. And Ryan, I know has been living and breathing this for quite some time, so I will greatly defer to him with regard to a lot of these questions. But I will say, as far as 4C1 is concerned, I think the intent of that is the surveillance piece, so conducting surveillance. And we wanted to ensure that officers don't conduct surveillance just for there needs to be a law enforcement or sort of public safety purpose, which I think, as you guys mentioned, needs to be fleshed out a little more. But that is the intent of 4C1, is to ensure that, I guess, is to separate out the blanket surveillance from any official law enforcement or public safety definition or purpose.
Yeah, I mean, that should just be conducting surveillance, period.
Agreed.
Yeah.
So it's kind of it's a small point, but I think it might be sort of a useful framing when you think about this, because what this policy, you're prohibited from basically spying on, basically not spying, you're prohibited from surveilling protests and people's free speech, exercising their free speech. But if, say, people are exercising their free speech and then a public safety incident happens to happen in proximity to them, then you're going to be flying, like say there's a during the counter protest in Charlottesville. You wouldn't want to have the police surveilling the counter protesters, but say when that guy drove his car through, they could then survey within that crowd because they're not surveilling a protest. You're now monitoring a car crash, and so that's I think the fundamental difference. And kind of just piggybacking off what Alex wanted to say, and that's kind of how I've been framing it to people who, when people asked about it, it just happened to be that there's legally protected First Amendment things, and then someone does something that is unrelated to that, just in proximity to them. So that's what you're actually looking at. You're not the counterexample of, say, two groups of people who are in an altercation. Well, just two groups of protesters marching near each other is not a thing. But the minute someone starts swinging a fist, you're now no longer looking at a protest, you're looking at a physical altercation. And that then is the person's at that point not engaging in civilly protected speech. They're beating they're beating somebody up. So that's, I think, just a way to frame it.
But then that would also already be counted under the probable crime. I agree with Commissioner Coleman's agreement about just saying shall not be used for surveillance, period. There was, Mr. Damascus has brought up another point that about the real-time crime center, that is.
Can we stick with
Sure.
where we're at for a minute so we resolve it?
Yep.
Yeah,
you got it.
So am I hearing some agreement around eliminating number 4? Is that what you're saying? I mean, it feels like that's where we're headed with
I could
this.
just remove it. Hold on. We're going. Hold on. You're asking us specifically on,
B4 on page 4, bottom of page 4.
and you're asking the proposal to just remove
Is
that.
that what I'm hearing? I'm trying to see if that's. It seems like that's where people are
I
headed.
think it depends on whether or not we want to define public safety.
Right. So I feel like, from my perspective, number 3, B3, other circumstances where it's probable cause that a crime is being or has been committed or public safety is being endangered, that would meet me. I feel like that's talking about public safety. To some degree, unless we still need to define public safety.
I think one option could be, so I think to Commissioner Coleman's point about the list under 2,
I mean, sorry, but if, you might as well just talk about it in public, so yeah.
because the pre-authorized use, if something falls under this list under 2, they don't need to get approval from a commander. So I think in that case, if any of these are happening, or if 1, 2, or 3 is happening, I feel like that does cover a lot of situations. And I think that I am of the belief that we should just remove 4, and that if this policy can be reviewed and updated, if CDP finds, hey, we feel like we needed to use it for this situation and it wasn't covered, they can always come to us and say, hey, we felt like this didn't meet this criteria, but we think it's a valid public safety use. We can always amend the policy at that time.
If I may, the committee could combine 3 and 4 to say something like other circumstances, including flying over large crowds, where there is probable cause. And then I think, the flying under a large crowd would be confined to, there being probable cause or imminent safety to citizens, etc.
I think that public safety is, in the context of public safety being endangered, feels different than public safety purposes, which is much broader, whereas public safety being endangered is.
And then it's limited by the requirements of the law.
Right. Okay.
And your thought to combine them would just be so it's easy to discern, okay, I've got a large crowd situation, where do I look, essentially?
Yes.
Is that the perfect?
Yes. And anticipating that there are circumstances that might require or we would want to permit the division to use it, while still limiting it by probable cause or endangerment of officer safety or public safety.
to the chair. So having heard the points made so far, I think looking at it again, to points that have been made, the pre-authorized uses, the only point of clarification there is, can you do that during a large crowd, right? So we're making it confusing. In the pre-authorized uses, right, do those apply if we're dealing with large crowds? The reason large crowds came up is two different things. One, the FAA has very strict rules about flying over large crowds, right? So it's an issue in general with drones and having them above massive amounts of people's heads in case they fall down. And then it came up with protests, right? So what's the difference between a protected protest and a large crowd? Well, there's a lot of differences. So the Cavs parade is a perfect example. I wouldn't want the police to be restricted on a day like that from being able to fly a drone to find missing persons, etc., because they were afraid they couldn't do it during large crowds. So maybe the answer is just clarifying in that pre-authorized use that any of these pre-authorized uses can apply to large crowd situations, right? So if you're saying in the beginning, somewhere in that initial pre-authorized use that a large crowd still allows these things to be okay, even pre-authorized, you might solve that problem. So I think that's kind of been said, but there's a conflict because the confusion becomes, well, if I have a missing person and it's a large crowd, do I have to get authorization from the chief? Even though missing persons is pre-authorized, it says if it's a large crowd that you need extra permission for that. So maybe just clarifying in that pre-authorized use that these conditions are still pre-authorized, even if it's a large crowd situation, might be another possible solution here, if that makes any sense.
I think the only issue with that is there is the number 7 training, and I think I don't think we would want to say that they could use.
And are we all clear that as it reads right now, the pre-authorized uses apply no matter what in any situation? Okay.
Yeah, does it say somewhere that it says you can't
Right,
use
it doesn't.
I'm
right.
not seeing that yet.
So it doesn't matter if there's a large crowd, if disaster management happens, that's pre-authorized. Is that, are we on the, okay.
Adriana had their hand up.
Yeah.
Oh, so you guys said some of the points that I was going to make, where I think it's important to ensure that that we're able to exercise the First Amendment as well as ensure safety. But I guess even in the scenario you mentioned about the car, right? I guess my question would be, when is the proper time to ensure that drones are entered in the scenario? Because I'm gonna just say, for me, if I am protesting, right, I don't want the drones to come when the car is hitting me, right? So I guess that's where I'm trying to find myself in ensuring that we're protecting my First Amendment as well as ensuring safety, right? Because if the car is hitting me, that's a little late. Or if somebody is striking me, that's really late.
Preventative would essentially be surveillance. So that's kind of, yeah.
I was gonna say, Jeremy, I think that's the balance we're trying to strike here. Is that we want safety, but that old Benjamin Franklin quote, right? You can't. Those who will give up safety, what they say, will give up. What did they say? They give up their liberty for security. Deserves neither. Like we have to have a balance, because as Tara said, if we are going to be preemptively putting drones out over protests because of a fear, then we're essentially allowing surveillance. And then once those videos or photographs are taken, now we have another issue in our hands about sort of like, then where do those things live? I don't think I get your concern, but I think this is the balance we're trying to strike.
And to your point, I think so. And to John Martin's point, right? If the circumstances are such, it is likely for something to happen. I think that's, and that's just good policing. They'll be prepared already. So you would kind of be in the queue and ready to deploy just in case. But the policy would not allow preventative deploying, if that makes sense.
Yeah, you can always have the thing in the car in the trunk, there you go, in every situation. I want to respect the fact that you all are here, Sergeant Graham, Simon. If you want to join us and speak to the issues we're talking, please do. You can come to the table.
Can you answer this question?
I guess, as we discussed this particular section, if you have relevant thoughts or comments about what we're discussing right now, that might be helpful.
If you want to sit here, so you can reach out to
And unfortunately, our kind of expert on UAS, UAP was unable to make it tonight, so we're gonna have to kind of wait.
Okay.
So do you have any specific comments on what we're discussing right now? That would be helpful.
Nothing in particular.
Do you guys think of examples of where you would need that?
From a personal perspective, not my law enforcement perspective, I kind of agree with Commissioner Rodriguez that when the car's hitting me, it's a little too late. If we can have the drone up in the area, then we have a better chance of seeing that car and being able to do something about it before it starts hitting me.
All right. So, yeah, I think it seems like to include other circumstances, including flying over large crowds where there's probable cause that a crime is being committed or has been committed, where public safety is being endangered, that would meet the requirements for a warrantless search under the Fourth Amendment. I still feel like that addresses the concerns that we're hearing, while eliminating some of the vagueness of that section.
Thanks to the chair. This is one very important part here, having done this for years and years in my past career. When you know a protest is happening, and you guys are good at intelligence these days, right? So you guys have some inkling the protest is going to happen Friday at 5 o'clock in West Side Market because it's floating around social media for weeks, right? You already have a provision to work your drone into your incident safety plan for that, right? So that covers most of this. So the only thing left is that small window where you're caught off guard, right? For instance, those car meetups, right? Maybe you didn't catch it and it's happening spontaneously. That's where this last provision would come in where, okay, now it's a large crowd. How do we approach this? We didn't have a chance to pre-plan it, right? And you don't have probable cause yet, although you may, because if you have good other intelligence saying, hey, there's guns there or whatever, you might be able to use that probable cause and then do pre-authorized anyway, right? So that provision becomes less important now the more that I think about it, because the one we're arguing over about flying over large crowds should be 99% covered if you pre-planned it correctly or if you meet one of the first circumstances. So I think it is something that may open window to some of the concerns that we're hearing here now because the incident action planning is in your procedures in other places too, right? So all of your actions are supposed to be pre-planned now, and the pre-planning of that drone can be approved under that section, the section 3, where you have to get the chief's permission, right? So if you do everything the way your other policies say, including your protest policy, your crowd management policy, you should be good with all of this stuff without needing that extra provision.
Should that provision, is that supposed to say found in section 4? I'm looking at 3B1. It says as part of the written incident plan for outdoor public events, subject to the prohibitions found in section 2 of this police order. Is that supposed to read section 4 of this police order?
Good catch. Correct. Good
All right. So, that's helpful. I think we've kind of resolved that. So eliminate 4, we'll fix that. I mean, we still need to go through it, and there's some, grammatical stuff and things like that. So if you see it, let us know.
On the grammar front, if I could just mention really quickly, you use a lot of will and may or must. That's the one. Thank you, Ashley. In police policies, all of them, we use 2 words. If there's wiggle room or discretion, it's may. If you must do it, it shall.
Yeah, we've gone through and sort of dealt with most of that, so we'll look at it again, but yeah. So I think we were being very intentional about the ones that are left there, but we might have missed some.
I think we did that.
No, we did with
Oh, we
this.
did.
So Jason's point is actually making me rethink. We were saying 4C1 should be conducting surveillance, period.
Yeah, there's more to that. Go ahead.
Oh, but now he brings up a good point. So a protest is going to happen or demonstration is going to happen. You're putting together your incident action plan or your safety plan. If I am a chief trying to approve a safety plan, I almost wonder if keeping in groups within public demonstrations more clearly prevents circumventing what we're trying to prohibit. I don't know.
Yeah. That's something I was going to come back to. Another way to deal with that, because I'm looking at on page 4, section 2, subsection A9, other uses specifically authorized by court approval or warrant. So that's in the pre-authorized uses of UAS. So one thing we could add there is conducting surveillance would be prohibited without court approval or warrant. Would that I mean, I don't disagree with your approach either, because that's language that I've looked at a lot about the individuals and groups in public demonstrations, and that was in response to the community back in November, as well as some of our experts.
Well,
But if we added without court approval or warrant, it's just like conducting surveillance without court approval or warrant, that would also eliminate that from the safety plan unless there was a warrant.
yeah, I think it depends on what we want the ability to be in the safety plan, because they'd be hard pressed getting a court order or warrant without probable cause.
Right.
So
Yeah, so they couldn't be doing surveillance at a large gathering. They could be monitoring it without. So we might still want to keep the individual or groups piece in there. I don't know. I'm just sort of thinking out loud.
yeah.
So I see you're nodding your head over there.
It's just, I agree with the commissioner that just for a protest in general,
Right.
no, we're never going to get a court order, we're never going to get a
Exactly.
warrant for that.
That's why I want to put it in there. That's
Well,
I see.
but then you're eliminating any kind of public safety, which was mentioned by Commissioner Rodriguez.
Yeah, no, I hear you. But I think what we've heard very clearly from both our community members and our experts is that we don't want surveillance without a warrant. But I also don't. There are situations that are not the gatherings or whether you want to conduct surveillance. So it's a different issue, right? So if you may need to use it to conduct surveillance of if you have a situation that not a gathering or a public thing, but you want to see what's going on with where a crime might be committed. Is that surveillance or is that a crime? But I'm just saying, like, then you might have you have a warrant to go and get somebody in their house, right? And then in that case, you can use the drone to check things out before you actually show up at the door or something, right?
Mm-hmm.
So that's what I'm saying is, like, you can't ban conducting surveillance because you may, in situations outside of a large crowd, you may need to conduct surveillance with.
I disagree with that. I think I think the goal is to ban conducting surveillance, period. And you have those instances of where you have probable cause, where you have a disaster coming up, where, I mean, that's not conducting surveillance.
Yeah. but it-
Or is investigation in here? Okay, seeing documentation for evidentiary or investigatory value. I guess I cannot think of an instance that falls outside of the pre-authorized uses that would not be surveillance, if that makes sense. You know what I mean?
Sure. No, I hear you. Yeah. No, that.
But the officers, if there are instances you're thinking that where you would need to preventatively fly a drone that fall outside of these pre-authorized uses, that is not surveillance, I think that would be helpful for us to know. But to me, that doesn't logically, I can't.
Yeah.
I agree.
I just think in that case, again, I hate to keep going back to Commissioner Rodriguez, but that is that instance. You know, we don't know something's going to happen, but if we have the ability to fly a drone, not surveilling the crowd necessarily, but in a perimeter where we can see what's happening outside of that gathering, it gives us more tools to prevent injury. Even when we are serving warrants, surveilling the addresses keeps officers and subjects from getting hurt. You know, those are the kind of things I think of.
Because we monitor protests anyway. Sometimes protests move. So we're like, maybe the protest is not moving east. So maybe if they're in the street, we want to block the street to allow them to keep moving or something like that. Maybe the drone can help with seeing like a forethought of where the protest is going. Not necessarily surveilling, coming in on faces and stuff like that, but an overall consensus of where the crowd is moving to. Is there danger ahead? Are they headed to a highway? Do we need to block something? Do we need to do anything to protect them for their safety? Is there a car coming or something like that?
So I will note that on March 8th, and I was talking to Commander Slot at one point, he said, what do you do? I asked him what he does what do y'all do when you don't have drones? You use a helicopter. On March 8th, the Women's March, there was a helicopter that I saw. And I was pretty sure it was one of yours, but I'm not 100% sure. But there was a helicopter circling that march. So it seems like a different tool to do that with, if I'm not mistaken.
But to Commissioner Rodriguez's point, it's a lot cheaper to fly drones.
Yeah, but
I know the
rights
expense of flying that helicopter,
constitutional rights are more valuable to me.
and I understand that.
Yeah, go ahead.
I think to your point, one is the task that we are, as I think Commissioner Adams put really eloquently, is how do we balance public safety with protecting civil liberties? And it is y'all's job to be here to advocate for all the tools that you can use to effectuate your job as CDP to protect public safety. So you're doing
And protect you and your exercise of your constitutional rights.
Absolutely.
That is our job as well.
Absolutely, I appreciate that, and I see it, and so, like, I 100% respect that you're here to do that, and I expect nothing less in a positive way. And also, when we are trying to find the balance between how do we give CDP the tools that it needs to protect public safety while also doing our due diligence to protect civil liberties, one of the things that makes it challenging is that after we passed this policy, that very quickly it was deployed at a protest. And so when that happened, to me, part of where I'm coming from is, do we then need to be extra careful about that? And it's not to be like obtuse or anything, but it's just as when acting, where do we find that balance? After something like that happens, that tells me that we need to be extra protective of civil liberties. And so I think that, to me, again, if something happens that we feel like this policy then was too restrictive, we can come back to the policy and make changes down the road. But based on the information we have so far, was that it was used in a way that we felt like was, do you need to know?
Well, there was a that they used a draft version that had different language. So
But still, yeah.
Yeah, right.
Yeah. So to me, that tells me that I feel like we need to be more on the side of trying to be restrictive in order to protect civil liberties. The second piece is I agree about if surveillance could still be used if it is meeting one of the pre-authorized uses. So like that, it just the sole purpose cannot be surveillance. And so I think that the point of if there's a warrant, if there, you know, an example that was given during all of our interviews with council was what if there's a KKK rally or the Proud Boys are coming? If we have advance notice that there's some specific threat that is going to happen at those, that would be able to be used in a warrant to then say we've received information that that this type of crime is going to be committed at this rally. That can be used in a warrant, and that is then covered. So,
No.
no,
No, the warrant has to be probable cause of a crime.
That is.
so, but if there was someone posted online that says I'm going to do this thing, that wouldn't be probable cause.
Go to the judge, but I don't think we should think on that.
That's interesting.
I think at that scenario would fall under 3B1, safety action plan.
Okay, yeah, and then it would be like
Yeah.
this thing. They said this thing. And, okay,
So
Okay.
I want to get back to like that.
but there is something that
4C1.
Cameron said that I want.
Let's finish this part.
To the chair, I'm just gonna say for the record that this commission should not willingly or knowingly compromise constitutional rights. I understand the danger of the scenario that Commissioner Rodriguez put forward, but we cannot, things happen all the time that we cannot predict. And whether it's the KKK or the Proud Boys, they have constitutional rights just like everyone else. And if they don't present, something that allows a judge to issue a warrant, they have every right to demonstrate like everyone else does. And I just think that's going to be the line that I'm going to draw in the sand in support of this policy. If the policy is going to violate your First Amendment or your Fourth Amendment rights, then I'm going to vote no. I'm not going to support anything. I just think that because that becomes a slippery slope. That becomes a slippery slope where you've allowed some type of infraction, on people's rights. And then where does that stop? You just cannot open that can of worms because you don't know where it will end. So I'm just going to go on the record and say that I'm going to oppose that.
Great. Yeah, I'm totally in agreement with that. So I'd like to get to specifically since we've sort of dealt with that one issue, 3B4, 4C1, conducting surveillance. We talked about just putting a period after conducting surveillance. We talked about the without court approval warrant. We talked about the value of keeping the individual groups within public demonstrations or other large gatherings for crowd control. So where are we with that? I mean, you sort of like seem to eliminate maybe the court approval piece. But Commissioner Coleman, you particularly had some thoughts about that. I'd like to know.
I think, honestly, I need more familiarity around what goes into an incident action plan and the approvals for that. I guess without understanding whether or not 3B1 will essentially be a way to circumvent or C1, I'm kind of torn on how to revise it.
Right.
Where I stand now, it would be conducting surveillance, period. But again, I guess I'm just, and I have not seen an example of one of these safety plans either. Because there may be a way within that to, what the officers are saying, ways to, surveil routes or kind of do some type of pre-planning that is not necessarily surveillance of individuals or groups. But I just don't know.
So I would like to make a comment. So I do appreciate exercising our First Amendment right. I also know that in general, there's a variety of cameras, even on the street level. So with all due respect, if you're going to protest, that's something to consider as well. But typically, if it's far, I think it's important to say you're not going to do face recognitions. You're not going to explicitly target anyone, right? However, as I mentioned, I think your First Amendment right is important, but I also value life. So saying that in certain instances, such as you mentioned, as the KKK, especially in youth climate, right? Proud Boys, it is an extremely intense time, and there's just general concern, right? So just because I say, oh, I would like to ensure in proper instances that we have the ability for surveillance when appropriate, that doesn't mean I am intentionally violating anyone's constitutional right. I just want to make sure I put that for the record, okay?
To the chair, just a point, you have 5 minutes left roughly, so if you want to extend,
No, we had this.
oh, it's still 8, I'm sorry, I thought it was 5:30.
That was the original, that was the original.
Copy, that was the old agenda,
Yeah.
all right, thank you.
Yeah.
Then you have 35.
Okay. So it sounds like, do you have other examples of the incident action plans, or is that something we just made up?
No, we create incident action plans for everything from
Right.
large scale protests to, if we have a major league, sporting event downtown, we have an incident plan for the Cavs parade.
Right.
We even have incident plans for drag queen story hour.
Mhm.
So we do create action plans on a regular basis.
Right. Can you talk about like what?
I'm not familiar with the creation of those at all. We have an events coordinator that handles that.
Can you talk about like what they? Not the creation of them, but sort of the content, what they kind of their focus. Not really.
Not really. No.
Okay.
I know it identifies what units we're going to use for those things, but other than that, I'm really not too familiar with them.
So I think the concern is for C1, if we just say conducting surveillance period, if then under 3B1, it says that they can use it,
Yeah.
C1 under 4C1, our concern is that if we say conducting surveillance period, that then under 3B1, that if in this incident action plan for outdoor public events, if they have written in use of drones for surveillance, that these two parts of the policy would be in conflict. Am I understanding that? Is that the concern? Because I think one thing that in what I see it being useful for is traffic. And I think I could see that to me as something you would write into an incident action plan is being able to look at all of traffic, in terms of when crowds are moving. I think about a Cavs game or a Guardians game at the end, officers are on foot, they might not be able to see it realistically. That is a type of surveillance. However, if we think about conducting surveillance of individuals or groups, I wonder if there's, for me, what I keep coming back to is vehicles and like traffic patterns. So is that a carve out we could write in that conducting surveillance with the exception of like traffic patterns? Because then if we were to see a drone, if there's drone footage that zoomed in on someone's face or on a group of people's faces, it would be very clear that that wasn't traffic related. And then I feel like that would be, so I think that is like a carve out that I wonder if like we say conducting surveillance with the exception of traffic and vehicle patterns.
You already have in 3B1 subject to the prohibitions
Yeah.
found in section 4. So it already sounds like you guys put the guardrail on it already.
Right, I mean, I think you should have be finished.
Yeah.
Because I feel like that goes back to the original language where conducting surveillance of individuals or groups within public demonstrations. That might, I mean, I'm fine. I would be okay with just period, conducting surveillance period, but it could be an argument say really specifying, that it's
I think
people versus
That's what I'm
cars.
Yeah, I think you articulated especially what my concern was very well, and what she's saying is kind of why I was going back to think maybe we lead in
Yeah.
individuals or groups or whatever, so that if you have like a sheer traffic type situation that could be into the safety plan, you're not limited. So thank you. You said that much better than I did, but that's what I was trying to articulate.
Well,
So
I
that would
don't,
be
I don't know about
something
that, but I guess,
that-
thank you for the compliment. I guess my concern is traffic patterns related to vehicles is different than traffic patterns of groups.
Or an individual,
Yeah.
So that's why if we leave the language
I'm
of
thinking
individual
leave
groups
it
within
in.
the public, then that prohibits that use, but it does not prohibit.
I will.
When I think of
okay.
surveillance, I don't think about cars. I mean, I feel like
Oh, okay.
I
I
think
will
about
say
people.
once a drone's in the air, I mean, there, our ability to regulate it is at the deployment, right? So
Yeah.
once it's there, we're not gonna know
That's true.
if they are surveilling. So I will just throw that out there.
Okay. Okay, yeah, thank you.
So I guess just for clarification, when are we saying that it should be deployed then?
Two,
And yeah,
two or three, 2 and 3.
To the chair, we made it very clear so there was no confusion. You can bring this drone to any thing you want, right? It's when you fly, you have to meet standards. So there's anytime the police anticipate that they can even set it up, get it all ready, right? And it can be there if they're concerned something is going to go, right? So we put no prohibitions of bringing it to the event or to the call, because we were concerned that they would read into it that they can't bring it, but that's not true, right? And if you've ever seen a drone, if it's ready to go, you can have it up and get it somewhere real fast. So we're talking about micro minutes here to get it up in the air to where it needs to be if it's already ready to go and pre-deployed. So we don't have any restrictions on where they bring it and having it ready, right? So bringing it to a protest and having it ready in case something happens and it turns what they use the terminology violent, right?
Well, and I don't want to put the assumption that our protests are violent. I want to put that misnomer. No, I don't want to put that out there. But let's just say in an instance, okay, so we have it loaded, ready to go. It's up and running. So then they make the call, it sounds like, receive whatever they say, create a report or whatever they need to do to get authorization at that time is what we're saying, right? And then they would just let it fly.
So through the chair, to the commissioner, if it's already pre-authorized, they don't have to wait, they could fly. So there's that section in 1 there that says if it's pre-authorized if it's any of these things, right? Yeah.
So I guess I'm speaking in the instances where it's not pre-authorized, okay? And then, okay,
There's pre-authorized, which they can just, if it falls in that category, they can do it. But then there's section 3, where those instances will have to be approval by like the chief or whoever they designate.
so what I'm saying is, at that time, there's something so they have it at the actual event.
Right.
According to you, they can have it ready, locked and loaded. Then they should call the chief at that time.
Nope. If it's section 2, they don't have to call.
Yeah.
If it's 2,
Right. If it's
three,
section 3,
the chief has to
if
be
it's section
involved.
3, typically and always for larger scale events, you will have an incident commander who is always typically a command level individual. It may just be some of these smaller events where I wouldn't think, like, we don't have a commander as the incident commander for Drag Queen Story Hour. But any kind of major event, there will be a commander who's in charge of that event.
Okay. So I feel like we're back to the original language on 4C1.
yeah, that's where I'm leaning.
Okay. That sounds good. Commissioners?
So, Mr. Damascus, brought up some concern about the RTCC and the dismission, the real-time crime center, and the transmission of data. I think I don't understand enough about what the real-time crime center is doing with drone footage and what they're, like, how then, sorry, it's on page 5 under, prohibited use about the transmission of, so Mr. Damascus had some concern that the real-time crime center is surveillance based. It's like is a surveillance activity. And my response to that is I don't feel like I understand enough about the real-time crime center to be able to speak to that definitively. So I think the question is, I understand that the drone footage has to be sent somewhere in order for people to view it. And so it sounds like where that footage is being, when it's being flown, it's being sent to the real-time crime center, and that's where somebody is viewing the footage, correct?
Correct. And the real-time crime center has access to other cameras, to ShotSpotter, to vehicle locations of the police cars and EMS. I'm probably forgetting a few
Body
things.
cams even, they can
Body
turn on
cams.
any officer's body cam in real time.
Yeah. So that, I mean, but if we have the restrictions on surveillance, then they can't use that. It won't, that won't be used unless there's, it's subject to all the other conditions previously. So what RTCC gets is what's allowed to be gotten under this policy. Now, there are bigger issues here around FUSIS and the real-time crime center that we can't deal with in this GPL.
I think that was also what my thought was then once it's at the real-time crime center, is it then
Right.
sent to other places? But I think what you're saying
So
is
we have
that
to deal with that.
that's a separate.
I think, yeah.
Pete, on that same provision, why is it UAS not transmit any data except between UAVs? What's the distinction?
So the UAS is the system as a whole. The UAVs are the individual drones, basically.
Okay.
Right? Is that accurate? No, there's some conversation. No?
So I was
Okay.
gonna bring that up.
Okay.
In our last meeting, we talked about that. And we decided to only use one as the terminology referring to the drone. But it looks like you still have both in here.
Well, yeah. So we didn't decide that. We took that input and we looked at it and we did eliminate a lot of the mentions of UAVs, but in some cases and in the definitions, we still got questions like, well, you're talking about the system as a whole, and unless there's a misunderstanding, a UAV is the actual vehicle that flies, right? So
It was my understanding that it was the UAS was the drone, is the drone.
And I'm not familiar with it
Yeah.
enough to say, but from what I understand about the UAVs, the only thing you have, the system is the drone and the box that controls it.
I think that's what I think Pete is
yeah,
saying.
right. No, I understand that. Yeah, I wrote that, or I helped write that. So yeah, but it's this. I mean, as we understand it, it's like the overall collection of drones and how they communicate, and yeah, I mean, let's.
To the chair, well, we got to think a little bit ahead, right? If we limit it to just one drone, it'll be 6 months. They'll have a system where 3 or 4 drones can coordinate with each other in the air. They're already doing it. I mean, they do. So the system is more in the context of how other institutions use it, right? If you have more than one interconnected series of drones or control panels, that is a system itself. So I think leaving the definition in there prevents you from having to come back and add it in when they grow and and it becomes more than just a one flying thing with a remote control. The system can become something much larger, series of coordinated drones, a series of different pilots, different component technologies that go into it. So leaving it as that. There's way more advanced things that are considered UASs than we have right at this moment.
Okay, I would just say there's some parts in here that it says UAS where it should be UAV and vice versa. So we just have to clean it up so that it flows when we're talking about a drone.
We can clean that up. We can look at that.
If I may, Ryan and I went through this tirelessly and really differentiated for the provisions where UAS made sense or UAV made sense. sense. So I think to the extent, the division believes that there is some uncertainty, if you could call out those particular provisions so that, the commission can consider those, that would be helpful. Otherwise, I know that those distinctions were purposefully made.
Well, I still don't understand the difference. Can you tell me?
And
the
I
distinction?
had to learn a little bit of it as well. I will defer to my esteemed colleague, Ryan, who I know
Because
has.
the definition says it's a system of UAVs. To me, that just
Yes.
means multiple.
And the system encompasses the UAV along with the data collected as a result of or from the UAV, along with the remote control associated with the system. And I'm probably missing a slew of other things, right?
So the distinction is when we use UAV, that's meant to be instances where that drone is not collecting data.
No, it's just meant to be that drone, period. The data is a part of the UAS, it's a part of the system.
It's like you're a crow versus a murder. A crow versus a murder.
A what?
Or a forest, a tree versus a forest, right?
I'm not sure,
Is it
and I will
one
say,
versus many?
I
Is that the
believe
difference?
that these are some definitions that are lifted from the FAA, so, we can
Yeah, no,
ensure
probably.
compliance with FAA by virtue of following and using these definitions. So if there's any sort of instance where, the division is unaware of the differences or what it means, there's FAA regulations that are comprehensive in nature and the division.
But are you saying the difference is essentially one versus several, one versus many?
That's one scenario.
Here, I'll read it right from the unmanned aerial systems is very easy to differentiate. This kind of explanatory on the drone pilots like hub. So it's very easy to differentiate from a UAV. In simple terms, a UAS is the totality of everything that makes a UAV work, including the GPS module, ground control module, transmission systems, camera, and all the software, right? So you can fly a drone without a camera and attached to it, or maybe they add infrared technology to it, right? Maybe they put a missile on it. That makes it part of the UAS. The drone itself is just the drone. So that's the UAV. And that's what they typically refer to the drone, right? The system is everything you put on it, plus the controls, plus the GPS, plus everything. So does that help?
It definitely does. So what would, now I'm confused as to what would be an instance where we need UAV and not UAS? Or maybe it's the one I just asked about, the 4A.
I think that's in four.
Okay, yeah, I see that.
Yeah, in 4A, it's basically saying that UAVs cannot transmit data to one another.
Well, it says it can between.
No, to a UAV cannot transmit it to each other.
It says it can do it.
It says it,
Except between UAVs.
no, it says between UAVs.
Yeah,
Oh, I
UAS may
interpreted that as two UAVs to the crime center, but you're saying
It's saying,
between UAVs and to, okay, sorry.
it's saying that it's saying that the system cannot transmit any data
Except
with the UAVs, except with the drones. So it's saying like it can't.
Oh.
Maybe if there's another place where data is collected, that information cannot go there. It has to stay here. That's
And
how I
to
interpret it.
to the chair, there have been times where we've passed things with a provision to fix things, right? So like if you wanted to move this forward, you can say with the direction that staff will clarify UAS versus UAV clearly before it goes back. So if that way you don't have to go through every one of those tonight, and we can do that as a mandate from you if you were to move this forward to clean that up and make it very clear in there, and we can work with the division.
And it does
I
sound
would
like,
say from the
right.
division's perspective, anything that we think might be one or the other, we'll be more than happy to let you know.
And thanks, sounds like a lot of work has been done. Thanks to Ryan and Alex for really clarifying that. Ryan in particular, okay, thank you. If you have any in a moment, that would be helpful, but if not,
We'll let you know.
yeah, okay. Okay. Sure.
I move to advance the division unmanned aircraft systems GPO to the full commission for approval to be re-reviewed by the division.
Second, somebody second, there's second. I'll second the motion. There's a little more discussion, but yeah, because I want to include.
I had comments.
Yeah, there is.
Yeah, we can keep talking. We can keep talking now that we have a motion.
Oh, I don't know.
Can you just to be clear, so the motion is to advance it as is or with changes that we already discussed?
With the changes that we already discussed and the directive to the staff to clarify the UAV, UAS situation.
So the specific changes would be just clarifying questions to the chair. The elimination of that in section 3. What is the
Section
are
3,
we eliminating that?
B4, eliminate section 3, B4.
Elimination of section.
There's some grammatical things we can fix. But
3B4, okay. And the UAS and to deconflict UAS and UAV.
Okay, so there was Commissioner Colbert, Sarah, yeah.
Yeah, there was just maybe only one that might be a typo. Well, okay, no, two that I have. Under the first page, where based on John Martin's comments, he has for page 1, lines 13 through 15, where we change it to A, B division's mission, provided such efforts not invade.
Do not, it should say.
That-
do not.
That's what I was wondering, but
Yeah.
maybe as I said it out loud, it kind of did sound right. But okay, that was I was wondering if that should be a
Yeah.
do. And
Yeah,
then
we can fix those
and we
as we go.
got it.
Yeah.
Okay, and then the section. Well, then I'll just say to modify the motion then with any non-substantive.
Yeah.
Grammatical, because like we got to change the 3A or the 3B1 thing. That's got to say section 4.
So there's a motion to amend the motion to eliminate it for technical errors.
The motion is to move forward with Commissioner Benito's motion, modified to include the ability to change non-substantive.
Just to avoid an unnecessary vote, I withdraw
Just
my
withdraw it.
motion and then I will remake the motion to include, we advance this with 3, with the exception, 3 things that will be changed. One is section 3B1. The second is to deconflict the UAS and UAV, and third is to make unsubstantial, substantive,
Non-substantive.
non-substantive grammatical changes. Good point.
We're going to start the ground, right?
We still need.
I have a question which I meant to bring up before, but so I apologize for not doing that. But section 2 on page 3, A7, it talks about training. And I'm looking at, wondering if we need the training one in particular, given what happened in November, where they said they were using for training reasons, and even though they were using the wrong draft, not the final draft of GPO, and it hadn't been approved by the DOJ. If you look at this, they said they were using for training at a protest. So then we look at on page 5 where we decide to leave in section 4, subsection C1. Do we have to specify under training that it says except for prohibited uses? Just to be
I wouldn't. It'd probably just be for that whole thing,
the
right?
whole
Like
section.
we would want to make sure. That the pre-authorized uses
So no,
never mean that you can do any of the prohibited uses.
right. I mean, it doesn't say that. I mean, it's an assumption, but we can't assume anything, right? So, do we need to add that language?
It wouldn't hurt. You could just put
I mean, the one it's most relevant for is the training one, but I could imagine, there may be others that we don't.
I mean, I would say add something. I mean, I was leaning towards adding something more specific to the training because we're not specifying like how they will determine where they're going to do the training. So is it possible? I guess no, but then there's all the potential prohibition. I don't know. I just would like to have a scenario where there couldn't be what happened at the county executive's home where the explanation was it was Trinity.
Right.
Right. So this is but I don't know if that is needed because we do have these other things in the policy that would prevent it from being used that way. But I just feel like just saying training is like completely too open to me.
So I guess to that point though, if there's a mass casualty incident, they might be conducting surveillance to try to find the person who, like if there's a mass shooting. So a mass shooting is gonna count under mass casualty incident. However, but conducting surveillance of individuals or groups within public demonstration, then if we're saying that they're what?
I mean, could the argument be made that we're not surveilling, we're training?
No. But I'm saying though, if we say the pre-authorized use cannot conflict with prohibited use, what I'm saying is in a situation where there's a mass shooting,
Okay.
and then you're looking for you're using the drone to try to find the shooter. If a mass shooting happened at a protest, if we said that they cannot conflict with prohibited use,
Add that under
they would.
So maybe we add number 10 that says that.
What I'm wondering is if we just specifically say
What you just said.
under training.
Oh, I see. You're saying instead of, because I was proposing to say like A, it would be like comma, subject to the prohibitions in section 4. And she's saying if we do that, then there might be like a disaster management scenario that leads to surveillance.
Correct. Oh, but within a crowd.
But could we, I guess I'm saying is, could we just, where it says 9 other uses specifically authorized by court, could we add what you said as number 10?
To where?
Number 10 under that same section that says that that the pre-authorized uses cannot.
Where's number 10?
On page
No, there is no
4
number 10.
top.
There's only a number 9.
There's number 9.
Okay, can we add what
Oh.
you said as number 10 to make sure there's no conflict?
If I may, I think that the prohibited uses are the prohibited uses regardless of 2 or 3. So that's the prohibited uses is the rule. Essentially, the number 2 is the pre-authorized always exception to the rule, and then number 3 is when you need additional approval to implement that rule. If there is some uncertainty regarding training. I don't know how it's been used in the past, but we could add a provision or add a qualifier saying, non-real-time training or off-site training or something like that.
Yeah.
I like that.
That's all I want. Yeah,
There you
that's all
go.
I
That makes
want.
I like that.
So since we have a motion on the floor, if we're gonna make an amendment, just add, if you would mind going through the process of just.
Yeah, so the amendment, I would,
If I may, just for future practice, we can flesh these issues out fully in committee before we make any sort of motion to amend. If you guys believe that you're at a place where you've talked everything through, where you're comfortable with advancing everything, then I would make that motion.
Sure.
To the extent it's still being sort of discussed informally, I'd say that there's no motion that needs to be made.
Or we could just withdraw. There's one on the floor though, so we can withdraw that until we're ready to.
I withdraw my motion and I'll wait to make another motion until we're sure that I didn't realize there were more things.
my
I
apologies
apologize.
for not jumping in with that.
That makes
I
it
did
easier.
ask.
We go back to just regular discussion then.
I did ask to be fair.
I'm just trying to get us in the habit of formality, so I know it's annoying, but when there's a motion, there's a process to change the motion.
So the language for 2A7 would then be training.
Off-site training. I don't know where the training is conducted or how it's conducted, but
Only scenario-based training. Like it's not real time, like it's not.
not.
What if he said? If he said something non-real time or something like that? Maybe just go back and put
What does that
What was
mean?
language?
Like when you read it, like I know we know what it means because we're talking about it.
Following, are you tracking this? What language?
Yeah, I'm listening. I'm just not sure how to because I'm not sure how, myself, I'm not sure how they conduct the training. So I don't know. Go ahead.
I think, like, for example, with like weapons training, they're not conducting training in real
No.
time situations. They get feedback, but they're not conducting weapons training. So I
Scenario-based training.
so yeah, I think
That's
we
the
take
word.
scenario based.
Scenario-based training, we'll add that to
Because scenario means fake.
2A7.
Yeah,
Okay,
yeah,
I mean, it doesn't, but in this
yeah,
context.
yeah.
that's good. All right, good language. Thank you, Christian Vito. All right, now I think, are we ready for a motion?
Sorry, I don't know. That's got to be something with scenario.
I agree. I don't know the nomenclature that the division uses or how they conduct the other training, but if there's a training policy in place already, then I think the training would sort of, you'd have to look back at that policy to see sort of what the definition of training is or how training is implemented generally, and then I think that would fall under that specific GPO.
I know that we would say classroom and scenario based training. Because I believe that's the two ways that training happens is in the classroom and
So
scenario.
scenario based is defined somewhere in a GPA is what we're saying. Okay.
It's what they do on the training committee. So when they train officers and like use, or we've done a couple of these incidents for the public, but they use scenarios in their trainings with like dealing with mental health or even dealing with people having weapons. So I think that's like language that they already use in the division.
I understood, and I understand the concept of scenario-based training, but in this instance, we're specifically trying to prevent training being an excuse for a real live situation. And while scenario-based training colloquially means like this is a fake scenario, the words in the policy don't say that. They just say scenario. So it's like there was a scenario when we were training.
Yeah, no, but they use that to mean.
So I'm understanding we're good with scenario-based training, or?
If we're confident, yeah, that's defined elsewhere, then I'm good with that.
So now we can entertain a motion unless there are further.
I think what are we saying? Why don't we just get it final and then pass it instead of
Or do we have more to go through? Because we're this time we're at.
Yeah, we have 5 minutes, so can we make a motion?
I think we table it.
Yeah,
Have more comments?
I
Okay.
have a few comments. I don't want to go over any time, but it was one specifically when you talked about supervisor responsibilities, and you said UAS.
You get the page. And also,
It's
don't feel like
page
you
9.
need to extend the meeting.
Don't worry.
Yeah, we're
Page
good.
9. Page 9, section 9.
Yes, UAS administration, supervisor responsibilities. The UAS supervisor shall be responsible for the following. Who is the UAS supervisor? Also, in this section, you mentioned some things that about roll call. Upon section F, upon completion of roll call, providing CCS a list. So it sounds like there's two separate supervisors in this section that you're referring to. The roll call one would be specifically either a sector supervisor that conducts roll call or a unit supervisor that conducts roll call. And versus the UAS administration supervisor, are we referring to the supervisor that oversees our UAS systems as a whole, that would be doing like the administrative portion with policy or protocols and stuff like that? That would be a separate supervisor. So I just need clarity on that. Because all of these now is that any supervisor will be doing all of these tasks, which doesn't sound like would be the case.
So I think I'm going to make a motion that we extend our time so we can keep talking. All in favor?
no.
No, you're good. You're good. All in favor?
Aye.
But I didn't say how much time. It's 15 minutes. All in favor, please? Yeah, these are.
Page
Page 10,
at the bottom.
section F, at the top. So it's just like the responsibilities there. It looks like you're talking about the UAS supervisor, and then some of the duties there sound like you're talking about a sector supervisor at a district or a unit.
So how did you get to section 10, or are you just talking about
Page
this
10,
section?
page 10,
Right, that's
section
the uncompletion protocol. That is, yeah.
So just to clarify, Sergeant, UAS supervisor did not come from the division. That is not your language in that. It's not.
Not that I'm aware. I,
Not UAS administration supervisor responsibilities.
Well, no, the previous thing you said UAS supervisor. You said who is that?
Oh, yeah.
So that is not your language.
Section 9 title is UAS administration supervisor responsibilities. The UAS supervisor shall.
We have
So
to
this-
define
I'm not sure who
that.
the UAS supervisor.
I feel like this
is.
language was in previous drafts, but who knows? So
Yeah, I'm not
who
sure.
is, like, from your, what's the right language from your perspective that would clarify this question of who we're talking about here?
With these duties, they have to go to somebody once this policy is released.
Uh-huh.
So, we have to define who
Yeah.
will be the
Who is
supervisor to do this, yeah. So, the roll call
So
portion,
the supervisor in charge of appointment.
yes, the supervisor who is gonna be doing, the duties in section 9, 8.
Unfortunately, without Lieutenant Mateo here, who kind of drafted a lot of this policy. I'm sorry, he drafted a lot of policy.
What's his job in the division?
He's currently in the technology section. So,
And we have to deconflict, just to clarify, we have to deconflict the levels of supervision, right? We know on scene, it's an incident commander, we have pilot in charge,
Right.
those are clarified, but we're talking about the administrative, who is the drone supervisor?
yeah,
Okay,
who's gonna perform these administrative tasks?
okay.
And do you all have a suggestion on like
Honestly, I don't,
who that's?
because I know they're gonna have trained officers who are deploying. I don't know what, if any of them hold any rank at all, or if they're all just officers or detectives. So, and I don't know that, you know, they have an overarching, like, we have a bomb squad, we have a bomb squad supervisor. I don't know if there's a supervisor in charge of this program.
Would it, through the chair, would it be acceptable if you did decide to move this forward to allow the division to provide the deconflicting for that? I mean, that's something we normally don't get involved in, is who's in charge of what. That is ultimately their determination in their operational section. So I don't have any, ideas, and I don't think the staff can contribute to that. Only the division can tell us who this would place.
Yeah,
under.
I mean, that, or we would language that would say the UAS supervisor to be determined by the division or whatever. Right? Is that adequate language?
That could work out.
But then we would still have to separate the duties between that person and then what our, road bosses are doing. They're,
So that's the roll call issue on that.
yeah,
And CCS there refers to,
Radio.
right.
right, and CCS lives and used there. So that, the supervisor who does that, the person who does that, the road boss, would be different from this UAS supervisor that you all identified. Are there other subsections of section 9 that would need to be removed? Or is that the only one?
That was so section F through I, looks like it would be all the road boss.
So the rest of that.
So above that would be the supervisor.
Yeah, unless they do have a supervisor designated with the drone, but I don't think they.
Okay.
I can clarify that with the lieutenant.
What's the formal term for a road boss?
Sector
Sector
supervisor.
supervisor.
Supervisor. Okay.
On the same page, section 10, D, I would just suggest one thing supervisor must request SIU to respond. Sometimes they're unavailable. So we would put something like if SIU is unavailable, the supervisor can process the scene or whoever we decide.
And in that case, it might be something as simple as, shall request units required to respond and process the scene, because this is talking about collisions, which may involve the FAA as well.
Okay. I mean, it seems like a technical process that I think we can improve the concept and finalize language. Right?
And to the chair, I don't think we made any edits to this. I think this was legacy from their drafts. I don't remember any
Right.
content being changed in the supervision or portions or the investigation
Right.
portion, other than clarifying collision a little bit based on UA.
I also don't want to forget about the officer's note of shall and no, of may and shall. May and shall. If we could just do a run, just a control F for will and must to
Yeah, yeah.
about.
KP,
So we're asking.
this is the original language, and this is the section on supervisor responsibility.
Okay.
And I think that, so I think we did add a few things, because on that draft, it looks like their draft included everything that was after F. And I think that's the things that we added before F were.
So we'll rely on the vision center. We'll, with the understanding that we will add language around the U.S. supervisor to be driven by the division shall be responsible for the following A, B, C, D, E, and then a section for sector supervisor for F, G, H, I. But we'll deconflict that. We'll make sure that makes sense.
And my last thing to mention is page 12. In our last meeting, we discussed the retention for the video from the UAS. And we talked about it being the same retention schedule
Yeah.
as WCS. So it looks like the other language is still here and wasn't changed.
Right.
So I just wanted to bring that back up.
I remember notes about that, and
Yeah.
it just got lost.
Yeah, I think because it would actually conflict, because
Yeah.
later in the policy, you say we'll follow the categories from WCS.
Right.
Right. Yeah, and also on page 13, section, what's that, 13, H, 16 H.
H.
Again, it's, oh wait, that's something different. I see. Oh, I suggested, because there's a lot of language in here about reporting, doing annual reports, reporting to the CPC, reporting. I would suggest just a section for reporting, because somebody reading this is gonna have to flip 3 pages to try to find what should I be reporting, because it's all throughout. And I would just say, just for easier read, I can just go to section here for reporting, and I know exactly what I need to do. So I'm not missing anything, and making sure I'm following what I'm supposed to do. That's just my last suggestion, is to put maybe a section for reporting, and then report for this reason, that reason.
If I may, Chair, first off, I think there's various sort of reporting methods and avenues, and so I don't know if one reporting section would make sense or make it sort of an easier read. I think if we divide it between the position that is required to report as it's currently outlined, that would make it easier. I think that the UAS supervisor is intended to be somebody appointed by the division. And to the extent that number 9F, it might not be sort of a duty imposed upon a UAS supervisor. This does not impose an additional duty upon that. It's not saying that the UAS supervisor needs a complete roll call. It's just saying upon the completion of the roll call, whomever might do that, provide that list as required under this.
I'm wondering if under H, section H, instead of asking individual reports to be sent to us, we just get a monthly report of the reports that were completed in the past month. Because how this reads is that they have 30 days to complete a report. Once they complete that report, we have to receive it within 7 days, which then requires them to just like constantly be sending us reports. And I'm wondering if we should just make it monthly.
But how constant would it be if they're not using the drones all the time?
Well,
I mean, if they're using the drones, I mean, there has to be some accountability.
I know, but I'm saying, does it matter to, like, we would still receive it, it's just we receive it all in one batch.
But if
So I'm just imagining if
that's
they
just,
have it,
I think
they're
that's
using
assuming
it.
that they're going to be using the drones more often than they may. Like
I
they
assume they're
may-
gonna be using it regularly. Do we not think that?
I think we should. I would think that.
Okay, that's fine.
I-
It's just a suggestion.
Okay, so where are we leaving this?
Recording.
Is this something we can fix, or, because Alex, what you were saying was, is there a change that would be required based on what you're saying, or?
So
Sorry,
operationally, I think it's up to the division to determine who the UAS supervisor is. I don't know if,
But the reporting,
More in here. This is just what I'm.
I'm sorry.
the reporting piece, you said to leave it not all one section, but to leave it, or put it in different, depending on the responsible party, right?
Correct. And I think that there are so many individuals involved in the deployment of and the review of it that I think it makes sense to, if you are a UAS supervisor or a visual observer, to go to this policy and say, hey, I am a visual observer of what do I do? So if it's not easily understandable by the division, there's nothing to prohibit the division from sort of making a flow chart or issuing some further guidance on clarifying the reporting requirements and if XYZ occurs. But I think it's laid out specifically for the division to determine if I am authorizing the deployment or I am supervising the deployment, where do I go to determine what my reporting requirements are?
And also, to that point, maybe this conversation then moves in some ways to our training committee, because once we pass this policy, training will have to be done. That will probably have to be revised. And so maybe how they report and some of these other newer things that are going to be put into this policy, maybe that then moves on to the training committee to figure out how do we then get officers trained or figure out how they train. We can do that as well.
But Alex, you're saying the UAS supervisor, it's a whole separate person, or how the sergeant was saying some of these roles already fall within us? Is it a role or road boss?
And they may be the same person.
But you're saying, Alex, the UAS supervisor may be that boss.
Precisely.
You just have to. Okay.
And I think that would be up to the division to determine who has that sort of title or role in the particular scenario.
Okay,
All right, so
go ahead.
Pete, I have a summary of all the changes within ready if you want me to.
Okay.
Go through it. You ready now?
Yeah.
Okay. So if you were to make a motion to pass this, the following changes would be included. Elimination of section 3B4, deconflict UAS versus UAV language, make any grammatical non-substantive changes automatically. The division will deconflict supervisor roles but not change responsibilities, and align language with WCS retention period.
Did we miss anything? Seems good. Okay.
And I think that clerical changes would encompass the may or shall
Yeah, right.
as well.
All right.
Does someone want to make that motion?
Yeah. Chris.
I'll just to streamline things. I guess I have a question rather. Is there a reason we are trying to pass this with all of the pending changes opposed to having it finalized and then passing it? I just didn't know
this is a lot, so if you're not comfortable with it, we can certainly consider. What we could do is we could make those changes and come back, for either a special meeting. If we want to wait a whole month, but
So just to clarify a timeline, advancing to the full commission, we have an opportunity for the full commission to operationalize this policy April 23rd. If the committee chooses to hold it, the next opportunity will be the fourth Wednesday of May before the full commission will be operating. So that adds 30 days to the department's ability to fly drones. That is considering if the DOJ approves it. So we're still a long way from getting these in the air, and we've already been 3 months delayed. So I know that the division, the city council, the mayor, they really want to get these things flying for those, the purposes where there are legitimate law enforcement need for this. So it is a consideration that you guys need to make, is that they've asked us to do it as expediently as possible so they can get these things in the air.
So the two options are that we pass it with that understanding. The other is that we could convene a special meeting next week. We could try to get this done as quickly as possible, and we already know it pretty well, so we could see if we can do a meeting next week.
I don't think it's a bad idea to do that, especially because we did not get to the second part of our agenda, which is discussion of priorities. But if that's not, if you feel like that can wait till the end of May, to the May meeting, then we could do that. But I mean, I think it's a good point that generally we do kind of do this where it's like there's changes that come and then we'll approve it without limit.
This is a lot. Yes, a lot of charges.
Yeah.
So we could decide to hold a special meeting next week if we can look at our schedules. And I'd like to set the calendar now.
We have an accountability committee meeting next Wednesday. Are there other days that we have meetings next week? So I think a benefit of that, it would also give us time to get the feedback from the division about the supervisor responsibilities.
But it's still a tight timeline because if we
Right now, it looks like, except for the 16th, we're clear next week.
Okay.
Monday or Tuesday. I'm sure we need to meet in the evening, or at least 5:30.
Monday's good for me, the 14th. Does that work for y'all?
So I need more time to review because I know we got this 2 days. I know we got this 2 days, and I know sometimes these things happen. And I did mention my concern about really understanding of when we have the ability to fly the drones and things like that. So I'm gonna sit down and have a conversation and make sure I understand and I'm clear before voting this through. But that's where I stand.
I was asking if you're available next Monday.
I get that. I might need more time. Is what I'm saying.
Well, I think we're at the point where somebody's either gonna make a motion to pass it
Or
right now or we're meeting.
So that's the question. Are you guys available on Monday?
I'm available on Monday.
Are you available on Monday, Sarah?
I'm not sure.
You're not sure?
Hey Siri or Alexa.
You want me to call you? Oh, wait, I'm
Siri? Right.
Should we in the car or something?
No. Just want to schedule it and I won't have to miss whatever.
So we would meet on Monday at 5:30.
Oh, wait, this one, no, actually.
Yeah.
No, because I am in charge.
Tuesday?
And right now we're at is Wednesday.
The
15th is what we're looking at
Well,
now.
we just, because we already kind of all did our schedules for Wednesdays, and should we just do a special one on Wednesday at the same time?
But there's a,
Well, there's already
Oh, sorry,
another
sorry.
committee.
No, but we,
which
our
committee
meeting
do
is
you
at
have?
7, the
We
accountability
could work,
committee,
do before.
so we could do
before
before
that.
that. We could do a 5 o'clock.
We won't need a ton of time, I would hope.
So
Okay.
hopefully we have the full draft and all the corrections by then,
Well, yeah,
right?
I think
Yes,
we can turn
definitely.
that around for you in what, a business day or two?
Yeah,
Can
and I
you
know
all do
we'll
that?
wait for them as well.
so we would try to get something out by Friday.
So should we do Wednesday at 6?
Five,
Right,
six,
that's what I'm saying.
at 5? You have something at 7? Let's do 5 then.
5, is that one?
Wednesday at 5?
Wednesday, the 16th at 5?
Wednesday the 16th at 5.
Okay.
I'll just make it 1 hour on the calendar. Is that okay? Well, I want to give some turnaround time for, we have another
We
committee
could do
starting at
5.
7.
So
So
5:30.
5:30?
Time. Yeah.
5:30 is fine.
5:30?
enough time to go over.
All right, with that, we will adjourn this meeting. A little bit late, but here we go. All right, thank you so much, and thank you to everybody who was able to make it here and get their input, and do the work.